Hello, welcome to Partnership Law. So now we are in the dissolution and winding up of partnership. Now in this part, dissolution and winding up, there we have to understand that the concept and the three stages by which the partnership is dissolved. Okay, so first stage we have the dissolution. The second is the winding up, and the third is the termination. So um, it is not by the dissolution only that the partnership separate juridical personality or existence is ended. Okay, but this dissolution or the ultimate termination of the partnership involves three stages. Okay, so first is the dissolution. It is the change in the relation of the partners caused by any partners or any partner ceasing to be associated in the carrying on, as distinguished from the winding up of the business. So the article or the law itself says or is saying that dissolution is different from the winding up of business. Okay, on dissolution, the partnership is not terminated but continues until the winding up of partnership affairs is completed. Also here in Article 1829, dissolution daw, hindi daw terminated ang partnership. So that is why we have to distinguish these three separate terms: the dissolution, the winding up, and the termination. Okay, so first sa dissolution, it is merely the change in the relationship of the partners caused by any partner ceasing to be associated in the carrying on of the business of the partnership. Okay, so iba siya from winding up, and it is also different or separate from the termination. Okay, so this dissolution terminates all authority of any partner to act for the partnership. Okay, so in dissolution, the partners may still act for the partnership insofar as may be necessary to wind up partnership affairs or to complete transactions begun but not then finished. So this means that upon dissolution, the partners or the manager of the partnership cannot act for the partnership business for the in order to continue the business of the partnership, the ordinary business of the partnership. Okay, the partnership doesn't have that juridical personality to still do business. Okay, but okay, the partners or the partnership still has that juridical personality, or the partners still have that authority to act or to do business insofar as the winding up of the partnership affairs is concerned. Okay, so hindi na sila pwede mag-act doon sa ordinary business, but they may still act for the winding up of the partnership. Okay, so that is what I call is the residual personality of the partnership. May natitira pa siyang authority ang mga partners, or ang partnership may personality na natira for the purpose of winding up. Okay, so the winding up is the actual process of settling the business or partnership affairs after dissolution, involving the collection and distribution of partnership assets, payment of debts, and determination of the value of each partner's interest in the partnership. Okay, so kinukumpleto na lang yung mga remaining business na hindi natapos ng partnership, and then dinidivide yung mga assets ng partnership, dinidistribute ang assets ng partnership to the partners. Binabayaran yung mga utang ng partnership kung may natira pa. So that is the winding up process. And then after the winding up process is completed, and then the termination of the partnership comes in. Then sa termination, wala na talagang personality, residual personality na natira ang partnership. So inexistent na yung cease to exist na talaga yung partnership. Okay, wala na siyang existence at the time of the termination. Okay, so those are the three stages of dissolution of the partnership. Now, what causes the dissolution of the partnership? Okay, it's provided under Article 1830. Enumerated in Article 1830. So first is the termination of the partnership without violating the partnership agreement. Okay. Yan ang first. Okay, so how is the partnership dissolved without violating the partnership agreement or the articles of partnership? So first is when it is by the termination of the definite term or particular undertaking specified in the agreement. So for example, if the partnership, under the articles of partnership, it is provided therein that the partnership would only exist for 25 years from the perfection, then so after the expiration of that 25 years, then the partnership is dissolved. Okay. And next is by the express will of any partner who must act in good faith with no definite term or particular undertaking is specified. So if walang term, walang nilagay na for how many years lang yung partnership, or wala silang specific undertaking na dapat gawin, okay, so any of the partners can say na he wants to dissolve already the partnership. Okay, it is, this kind of partnership is a partnership at will. So anytime any of the partners may demand the dissolution of the partnership without violating the agreement between the partners. Okay, and another for number 1 is by the express will of all the partners who have not assigned their interest or suffered them to be charged for their separate debts either before or after the termination of any specified term or particular undertaking. Okay, so if this just means that if any of the partners have assigned, for example, one of the partners assigned his or her interest to another person, so may sub-partnership agreement between them, all of his interest, for example, all of that partner's interest was assigned to another person, then any one of those partners who did not assign their share or interest in the partnership may demand the dissolution of the partnership, okay, without violation of that part of that agreement, of the agreement between the partners, even if there is a specified term or particular undertaking provided in the articles of partnership. Okay, kahit na may sabihin na, for example, may 25 years na nakalagay sa articles of partnership. Okay? Tapos hindi pa natapos yung 25 years, pwede na mag-demand yung kahit kahit sinong partner na hindi nag-assign ng kanyang interest sa partnership. Okay? Letter D. By the expulsion of any partner from the business bona fide in accordance with such a power conferred by the agreement between the partners. So, may na-expel na partner from the business of the partnership. Okay, maybe because of a violation of the articles of partnership or the conditions provided in the partnership, then they have an agreement that if someone violated, that partner would be expelled from the partnership. Then in that case, if any one of the partners violated the partnership agreement and he's expelled from the partnership, then there would be a dissolution. Okay, why is it that may dissolution? Okay, because as you can see in the definition of the partnership, remember, it is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on. Okay? May change na kasi in the relation between the partners. So yun yung first ground which has which is divided into 4. Okay, first ground which is divided into 4. Now the second ground is in contravention of the agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. So dito naman may contravention sa partnership agreement. Okay? So for example, may 25 years na nakalagay sa articles of partnership, and then wala pang 25 years gusto nang i-dissolve ng isang partner ang partnership, pero wala siyang ibang ground, walang sub-partnership, okay, walang expulsion, normal talaga ang lahat, okay, walang violation kahit na ano, and then gusto niya lang talaga mag-dissolve. Okay, that is in contravention of the okay, so kahit may agreement na 25 years pa dapat mag-end yung partnership, but anytime any of the partners can dissolve the partnership kahit walang ground, okay, walang violation of the contract partnership, walang sub-partnership, anytime any of the partners can demand the dissolution of the partnership. Okay, note that there is no such thing as indissoluble partnership, only in a sense that there always exists the power as opposed to the right of dissolution. So dito, wala siyang right to dissolve the partnership, but may power siya to dissolve the partnership. And in that case, because it is in contravention with the agreement between the partners, then that partner who demands the dissolution of the partnership may be liable for damages. Okay, so wala man siyang right, wala man siyang ground para ipa-dissolve yung partnership, pero gusto niya lang talaga i-dissolve ang partnership. So may power siya to dissolve that, but wala siyang right. Okay, the partnership may still be dissolved. Okay, ma-dissolve talaga yung partnership, but the dissolving partner may be liable for damages to the other partners. Okay, so this was in the case of Ortega versus Court of Appeals. Neither the presence of a period for a specific duration nor the statement of a particular purpose for its creation will prevent the dissolution of any partnership by an act or will of a partner. Among partners, mutual agency arises, and the doctrine of delectus personae allows them to have the power, although not necessarily the right, to dissolve the partnership. Verily, any one of the partners may, at his sole pleasure, dictate a dissolution of the partnership at will. He must, however, act in good faith, not that the attendance of bad faith can prevent the dissolution of the partnership, but it can result in a liability for damages. So next ground, number 3, is by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. Let's say, for example, we know, for example, drugs. Okay. So noon, for example, noon, hindi pa illegal na magtinda ng isang klase ng drug, or let's say marijuana. Okay, hindi pa illegal noon, di ba? But okay, so noon yung partnership ni A, B, and C, nagtitinda sila ng marijuana. But because subsequently there is a law prohibiting the use and the selling of marijuana, then it becomes the business of the partnership of A, B, and C, which is the selling of marijuana, would become illegal. Okay, so in such case, the partnership of A, B, and C will be dissolved. Okay, naging illegal yung business nila. Okay, so may dissolution na mangyayari dyan. Okay, when 4 is when a specific thing which a partner had promised to contribute to the partnership perishes before the delivery. In any case, by the loss of the thing, when the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership the use or enjoyment the same, but the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. Okay, so before pa na-contribute yung promise niya na thing to the partnership, it was destroyed. Okay, the thing to be contributed, then the partnership is dissolved. 5th is by the death of any partner. Okay, that's understandable. 6th is by the insolvency of any partner or of the partnership. So naging insolvent ang isa sa mga partners or yung partnership mismo. And then by the civil interdiction of any partner. If we say civil interdiction, it may be caused by siguro conviction of a crime where one of the penalty involved is civil interdiction. Okay, and civil interdiction is that concept or the term where a person is deprived because of a conviction of a crime of his certain civil rights or political rights. Okay, so kukunan siya ng civil rights niya dahil sa kanyang conviction of a crime. Okay, so hindi na siya pwede makamanage ng kanyang mga properties, hindi siya maka-enter into a contract. So of course, wala na siyang legal, for example, wala nang legal capacity yung partner kasi na-convict siya in the crime and was punished or to be imprisoned and also civilly interdicted. Then of course, automatically hindi na siya pwede maging partner. So, wala na siyang legal capacity. So, therefore, the partnership would be dissolved. Okay, and then by decree of court under Article 1831. Okay, so pwede rin na ma-dissolve ang partnership because of a court order, by a judgment of a court. And then, what are the grounds kung saan pwede maka-order ang court na i-dissolve yung partnership? Okay, so first is by on application by or for a partner. Okay, so ibig sabihin yung partner yung mag-file ng case sa court para ipa-dissolve ang partnership. So first is that the partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. Okay, so naging insane yung isang partner. Declared. Okay, take note ha, dapat judicially declared. So may court judgment talaga na nagsasabi na naging insane yung partner. Tapos yung judgment ng insanity, yun yung ipapakita or i-present sa court, okay, another case para ipa-dissolve yung partnership. Next is a partner becomes in any other way incapable of performing his part of the partnership contract. So hindi siya pwede makapag-perform ng kanyang duties sa partnership business because siguro migrate na siya sa ibang bansa. Okay, hindi niya magawa yung mga trabaho niya sa partnership. And then partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business. Okay, so siguro may fraud siyang ginawa. Okay, may mga falsification siya ng mga documents which is prejudicial to the partnership business. Then it could be a ground for asking the court to dissolve the partnership. Next is the partner willfully or persistently commits a breach of the partnership agreement or otherwise so conducts himself in matters relating to the partnership business that is not reasonably practicable to carry on the business in partnership with him. So may conduct siya na siguro nalulugi yung partnership dahil sa kanyang pinagagawa. Okay, not necessarily na illegal yung ginagawa niya, but because of that conduct, the partner he or she is putting the partnership into a loss. Okay, that his conduct is not practicable to carry on the business of the partnership. Then in that case, the partnership or any of the partners can ask the court to dissolve the partnership, and then the business of the partnership can only be carried on at a loss, so nalulugi na yung partnership. And then other circumstances which render a dissolution equitable. So this just means that the grounds that could be used in asking the court to dissolve the partnership are not limited to those that we have enumerated. So any other circumstance that are similar to what we have discussed, what we have enumerated, may be used as a ground for asking the court to dissolve the partnership. Okay, so if kanina it was on application by or for a partner, yung partner talagang nag-apply, pwede din na yung purchaser ng partnership's interest may apply for the dissolution of the partnership with the court. Okay, so pwede na siya mag-apply upon the termination of the specified term or particular undertaking. So natapos na yung, for example, 25 years, or natapos na yung specific job of the partnership, then the sub-partner may already ask for the dissolution of the partnership. Or at any time, if the partnership was a partnership at will, when the interest was assigned or when the charging order was issued. So, anytime, the sub-partner may ask the dissolution of the partnership if the partnership is at will. Okay? So that ends our topic for the dissolution of partnership.